name is Shelby Benson. I'm the Director of Outreach at the Mecklenburg Bar Association. We've been partnering with the library now for about a year to provide these info sessions to the public on various topics here within North Carolina law. We're very happy to have Rachel LaBruyere join us today. She's an attorney here in Charlotte. She primarily practices in labor and employment law, and I know she has a wealth of information to share with us in this hour. So I will go ahead and defer to her and let her share her expertise.
Thank you so much, Shelby. Thanks to you all who are able to join today. Like Shelby said, my name is Rachel LaBruyere. I'm an associate at Morin Van Allen here in Charlotte. And before I get started today, just need to give you a couple pieces of information. I'm not providing you legal advice today. I'm not representing you. I'm not your attorney. I'm here to give you information, not legal advice. And at the end of this slideshow, at the end of the presentation, I'm going to provide you with a few resources that you can connect with to the extent that you do need legal representation or legal advice. And Shelby's also going to be providing a couple of resources too. So even though I'm not your attorney, we can help connect you with an attorney. So today we're going to talk about North Carolina employment law. The main topics we're going to cover will be at-will employment. North Carolina is an at-will employment state, so we'll talk about what that means. We're going to talk about North Carolina and federal employment discrimination protections. So what laws are on the books that prohibit discrimination? What does that mean for employees? And then, to the extent that you're experiencing some of that prohibited conduct like discrimination or retaliation, what can you do? And the last thing we're going to talk about is both the North Carolina and the federal wage and hour laws, what's required under those. And again, to the extent that that's something that you have issues with, what you can do, where you can file, who you can talk to if you're experiencing things like wage theft. Okay, as we go today, please feel free to drop questions into the chat. Definitely want to make this as useful for you all as possible. So if you have specific questions, drop them in the chat, and Shelby will let me know when those pop up. Okay, so at-will employment. North Carolina is what's called an at-will employment state. All that at-will employment basically means is that an employer can terminate any employee at any time for any reason. This also means that employees can, quit their jobs at any time for any reason. Now, there are exceptions to that, but they're few and far between. Those exceptions are if an employee has an employment for what's called a contract for a quote unquote definite term. I'm going to talk about what that means in a minute. Or if you're terminated in violation of, North Carolina and federal anti-discrimination laws, or if you're terminated in violation of North Carolina public policy. What that means in terms of public policy is just the established public policy of North Carolina, which includes protections against discrimination based on race, religion, disability status, etc. So, these are narrow exceptions, but the vast majority of employees in North Carolina are at will, which means you can be terminated even if you don't like the reason that you're terminated, so long as the termination reason doesn't break the law. Your employer can terminate you basically for any reason outside of those. So a contract for a definite term, I think probably a lot of you, when you got your job or, the next job you get, you're going to be given some forms to sign. Most of those forms are going to be things like personnel records, but you may be asked to sign an employment contract. If the employment contract outlines the term of your employment. So in other words, if it says something along the lines of, after signing this contract, you'll be employed for 1 year, your contract will terminate at XYZ date. That's for a definite term. And I'll give you an example of that language in a second, but anytime you're signing an employment contract, it should outline the reasons that the employer can terminate you or the employment relationship and how that termination can happen. So if you do have an employment contract, if you've already signed one, or if you are, planning on signing one at any time soon, be sure to read it and keep a copy. If they don't provide you with a copy, ask for a copy of that contract. You want to make sure you keep it for your records. So let's say you already have an employment contract, how do you know if it's for a quote unquote definite term, which is an exception to that at will employment rule here in North Carolina? I'm giving you some sample language, which is in, legalese. All contracts are most all contracts are written in what I would call legalese. But so here we've got the term of employee's employment shall be for a period of 3 years, extended for 1 year each renewal terms, unless either party gives prior written notice of non-renewal to the other party no later than 30 days prior to the expiration of the initial term or the then current renewal term, as the case may be. That's fancy legal language to basically say you're going to be employed for 3 years. After 3 years, your employment contract could be renewed for 1 year terms at a time, unless you or the employer decide you want to end your employment. But you have to be given notice 30 days before they decide to end your employment if they don't renew your term. So this is language that would indicate that it's a contract for a definite term, which means your employer can only terminate you for the reasons outlined in the contract. If you've got a language like this that says, how long your employment will last, then make sure you read the rest of the contract to figure out what your employer can and can't terminate you for, and also pay particular attention to what's required for you if you decide to quit your job. That will all be in the contract. So that was a quick hit on at-will employment. Again, just to recap, North Carolina is an at-will state. Your employment can be terminated at any time for any reason, unless you have a contract for a definite term or your termination violates the law. Now, some of the laws that your termination could violate are what I'm about to talk about now. So anti-discrimination laws. First, I'm going to start with federal anti-discrimination laws, and these are really robust protections for employees. Some of you may know some of these. Some of these may be new to you, but these one quick note I want to make sure I mention is that these only apply to employers with a certain amount of employees. I want to say the threshold's like 25 employees. So if you work for a really, really small company, some of these may not apply, but the vast majority of employers are obligated under these laws. So first is Title VII of the Civil Rights Act. You're going to frequently heard it referred to just as Title VII. And that law provides that employers can't discriminate on the basis of race, color, religion, sex, or national origin. Part of what that means is they can't discriminate against you, for example, by giving you less favorable terms of employment. So let's say that you're a Buddhist, you practice the Buddhist religion, and your employer is like, well, because you're Buddhist and I know you're going to need these holidays off that we don't necessarily celebrate, I'm not going to give you those holidays off, or you're going to get less leave than other employees because they only take the holidays that we normally give. That would be a way that you could be discriminated against. That's a small example, but it's both discrimination while you're at work, like the policies and the treatment of you at work, but then also you can't base termination or what are called adverse employment actions on any of these what we call protected classes. So for example, if you think that you've been terminated because of your national origin or your race, that would be a violation of Title VII. If you think you've been demoted, or if you've been given a pay cut, or if you've been disciplined because of your status in any of these protected classes, that would be a violation of Title VII. In a little bit, I'm going to talk about what you should do if you do believe that you've been discriminated against in violation of Title VII. The second big law on the books at the federal level is the Americans with Disabilities Act. So this law prohibits the discrimination against employees on the basis of an employee's disability. One thing to note is that the ADA, you'll hear it referred to as the ADA, it defines disability quite broadly. But it has to be something that basically gets in the way of your everyday life or your everyday responsibilities at work. Um, in order to, so if you do have a disability and you're struggling with, keeping pace with something you're responsible for at work, or for example, something that comes up frequently right now is somebody has a disability and they're requesting to work remotely for part of the week because of that disability. That's what's called a reasonable accommodation. So under the ADA, you can request a reasonable accommodation from your employer because of your disability. And that means you can request an accommodation so that you're able to do your job, um, meet the expectations of your employer with that accommodation. Um, your employer doesn't have to grant you the accommodation you ask for or grant you an accommodation at all, but your employer does have to what's called engage in the interactive process with you. And all that means is your employer at least has to consider your request. Your employer may ask you for medical certification or doctor's notes to, ask about what the disability is and to determine what, if any, accommodations would be reasonable for you. To the extent that you request an accommodation and your employer either doesn't respond or, doesn't consider your request, that could be a violation of the Americans with Disabilities Act. Additionally, you can't be terminated or retaliated against on the basis of your disability. One really important thing I want to make sure I'm explaining here, though, is that you have to be qualified for the position and you have to be able to meet the expectations of your employer for that position with or without that accommodation. And that means if, for example, part of your job is that you have to be at work, on site, interacting with let's say you work retail, interacting with shoppers that come into the store, you have to be on site to do inventory, etc. If you request an accommodation to work from home, that likely is not going to be granted because you need to be at work in order to meet the expectations of your job. So again, it's a case by case basis on the ADA and requests for accommodation, but it is something that you have a right to the extent that you have a disability under the ADA. The final big law I'm going to discuss, and there's more on the books, but these are the big ones, is the Age Discrimination in Employment Act. You'll hear it referred to as the ADEA. This protects employees 40 plus years of age from discrimination on the basis of age. So, if you're an employee that, let's say you're in your 50s and you think you've been terminated and replaced with a younger employee, or you think younger employees are treated more fairly, they have preferable treatment, that may be a violation of the ADEA. So what do you do if you think your employer has violated these laws, either because you've been terminated, you've been disciplined, you think you're being harassed? All of the laws I just mentioned, Title VII, the ADA, and the ADEA, are all enforced by the Equal Employment Opportunity Commission. You'll hear it referred to as the EEOC. So if you think you've been discriminated against under any of those three laws I just mentioned, you can't just go and file a lawsuit in court. You have to go first through the EEOC. And so you can file a charge with the EEOC. This is a screenshot of what the home screen actually looks like in the public portal for the EEOC, and I've included the link here. You go to the EEOC, you file a charge. You may eventually be able to file a lawsuit, but you've got to go through the EEOC first. You can't go straight to court. The EEOC process it looks complicated. There are definitely multiple steps, but the basics are you file a complaint And the EEOC is going to reach out to you. They're going to ask you additional questions. They're going to, make sure they understand, what your complaint is, what you think the violations are. And then they're gonna first step they're gonna suggest mediation with your employer, and that just means can you and your employer reach an agreement about how to proceed. Either they're going to reinstate you to your position, they're going to put your pay back up to where it was if they cut your pay. That's a first step just to avoid the rest of this process. If either you or your mediator say, I don't want to mediate, or you can't reach an agreement, the next step is the EEOC will conduct an investigation. That means they're going to follow up with you. They're going to ask you a lot of questions. They're going to follow up with the employer. They're going to ask them a lot of questions. Often they do a site visit to the employer's workplace. They may talk to other employees that were involved with, what your allegations are, what your complaint says. So maybe your supervisor or a colleague or the person that made the decision to fire you or demote you, whatever that employment action that caused your complaint is. After investigation, they're going to again see if you can settle. Basically, if you can agree with your employer on, typically this involves like damages. So will your employer agree to pay you X amount of dollars for you to say, okay, I'm gonna, withdraw my complaint and proceed with my life. If you don't reach settlement, then one of two things will happen. Either the EEOC will file a lawsuit on your behalf. And I want to say that's very rare that the EEOC does that. They typically only do that if they think it's a case that has new or novel legal concepts, or if it's a case that's a priority for you right now, a priority for the EEOC right now. So, for example, currently the EEOC is prioritizing religious discrimination. So, to the extent that your complaint is about religious discrimination, it may be that after an investigation, the EEOC says, "Hey, this case has merit. We think there's something real here." And we'll file a lawsuit on your behalf. I would say 9 times out of 10, that's not going to happen. What's going to happen is the EEOC will issue you what's called a right to sue letter. That means, hey, we've investigated. We haven't found anything that means we want to file on your behalf, but you can now file a lawsuit in federal court. One big thing you need to remember is that once you get that letter, you have to file a lawsuit within 90 days. So if you miss that 90-day window, basically you waive your ability to bring a lawsuit. Let's say you get your right to sue letter and maybe you already have an attorney. Maybe after that you want to find an attorney. After that, you can file a lawsuit in federal court. It has to be based on the complaint that you filed with the EEOC. You can't bring in new claims or new facts. You can only file a lawsuit on the claims that were included in that initial complaint with the EEOC. So this is the best way if you think you've been discriminated against on the basis of race, religion, sex, color, national origin, disability status, or age. This is the best thing to do, is to file a complaint with the EEOC. Also going to talk a little bit about North Carolina anti-discrimination laws. You'll note that they largely mirror the federal laws, and frankly, their enforcement scheme is more robust at the federal level, but there are specific North Carolina laws on the books. And I'll talk a little bit about what you can do if you believe your employer has violated these laws, because there's some slight differences in terms of filing with the EEOC versus filing with a North Carolina agency. So again, 3 big laws in North Carolina. The first is the North Carolina Equal Employment Practices Act, otherwise known as NCEPA, which is a funny name, I think, but It, like Title VII, says you can't discriminate on the basis of race, religion, color, national origin. But unlike Title VII, it also includes age and disability, and sex. So those are the statuses that are protected under North Carolina EPA. There's also the Retaliatory Employment Discrimination Act, and this is very specific to North Carolina. That law prohibits retaliation against you for engaging in what's called protected activity. And in just a minute, I'm going to talk about all the different things that North Carolina considers protected activity under RETA. And then Persons with Disabilities Protection Act prohibits discrimination based on disability. And this largely mirrors the ADA at the federal level that we just reviewed. Okay. North Carolina Equal Employment Practices Act. It, again, discrimination on account of race, religion, color, national origin, age, sex, or handicap. And this applies to employers with at least 15 employees in North Carolina. So most employers, but again, if you work for a really small company, this law may not apply. So this law is enforced by the Civil Rights Division of the North Carolina Office of Administrative Hearings. And I have a link here for an intake form if you want to file a charge. Often, if you file with the North Carolina agency, it gives you the option of filing an EEOC charge as well, and vice versa. At the EEOC, you can file with the North Carolina agency as well. My advice to you is to file with the EEOC first and check that box that you also want it filed with the state agency. But to the extent that you're like, no, this is something that I want to make sure I handle in North Carolina. I don't want to go to the EEOC. This is where you would start. RETA, the Retaliatory Employment Discrimination Act. This is a little bit of a different law. There's not something like this on the books at the federal level. So, and this is a mouthful. I'm going to read it and then I'm sort of going to explain what it means. But discrimination or retaliation, including things like discharge, suspension, demotion against an employee who files that's misspelled, claim or complaint, initiates an inquiry, investigation, inspection, proceeding, or other action to testify or provide information to any person with respect to any of the following activities. So the protected activities include doing any of these things with regard to workers' comp, the Workers' Compensation Act, OSHA, the Occupational Safety and Health Act of North Carolina, North Carolina's Wage and Hour Act, Mine Safety and Health Act, on account of the fact that the employee has, if the employee has experienced domestic violence and has sought redress, so has like filed for a protective order, or has, say you've missed work to attend a protective order hearing, your employer can't retaliate against you for that. And workplace violence prevention. So what does this mean? Really what this means is, to the extent that, for example, let's say you work in a factory and you know that there are safety violations that your employer is not addressing, right? You're like, people have been hurt on XYZ machine or in this area of the factory, and I know that they're not following the law with regard to what North Carolina requires safety-wise. If you filed a complaint or a claim with North Carolina OSHA, basically reporting that your employer isn't following the safety protocols properly, or reporting that, hey, we've had a lot of injuries, I think, you guys should come and inspect, your employer can't retaliate against you for filing that claim. That means they can't discharge you, they can't demote you, they can't dock your pay, and they can't, just treat you differently, basically, with regard to your employment. Same thing if, let's say, you file for workers' comp because you've been injured on the job, you can't be treated differently or retaliated against because of that. If you file a wage claim, or if you make complaints about, violence at the workplace with the North Carolina agencies, you can't be just discriminated or retaliated against because of that. So if you, for example, let's go back to the OSHA example. let's say you've reported safety concerns, OSHA opens up an investigation, and then your employer fires you, and you believe it was because of this OSHA complaint. You can file with Retaliatory Employment Discrimination Bureau of North Carolina. You can file a claim with them. They have a really helpful, and I've got the link here. They have a really helpful process you can go through to figure out if you do have a RETA complaint. Like, do you think you potentially have a good complaint here, a good claim here? And the website will walk you through that. But these are, this law is slightly different than those on the federal books, but I wanted to make sure that I covered it here because it is specific to North Carolina. And it is basically what happens once you file a claim is that, like with the EEOC, the Bureau will investigate, they'll reach out to the employer, they'll do interviews, they will suggest mediation. There is a robust process for these complaints at the state level. The Persons with Disabilities Protection Act, it prohibits employers from not hiring, discharging, or otherwise discriminating against qualified persons with a disability due to their disability. So, unlike the ADA at the federal level, the PDPA in North Carolina allows you to just go ahead and file a lawsuit. Um, you you don't have to go through the EEOC to file a lawsuit under this law in North Carolina. However, if you've already filed an EEOC complaint based on the ADA, the Americans with Disabilities Act, the federal law, you can't just go and file a lawsuit under the PDPA. And I would say that 9 times out of 10, you should file with the EEOC rather than with filing a lawsuit immediately in court, mostly because it's going to give you the federal protections, which are frankly broader than the North Carolina protections. But that is up to you. I would consult if you think you have a claim, you should consult with an attorney about the best place to file. But this is also an option of going straight to court and bypassing the EEOC. So some of the key takeaways here, if you believe your employer has discriminated against you on any of these bases, you should file a complaint with the EEOC. If you think your employer has retaliated against you for initiating a complaint into things like OSHA violations, wages, domestic violence, you should file a complaint with the North Carolina Retaliatory Employment Discrimination Bureau. And again, I provided links in this PowerPoint. I don't know, Belinda, if we're going to circulate the PowerPoint, but I'm happy to provide it so that folks have access to those links. All right. The final thing I'm going to cover is wage and hour laws, both at the federal level and at the state level. And these are protections, in terms of how much you're paid, when you're paid, and making sure that you're paid properly, on time and in the proper amount. So the federal law is called the Fair Labor Standards Act. You'll hear it referred to as the FLSA. That's enforced by the U.S. Department of Labor. And a couple of the key things I would say under this law are that you have to be paid at least minimum wage, which is $7.25 an hour, which is still quite low. Additionally, if you are an hourly employee, not salaried, so if you're paid by the hour, you're not just paid a yearly salary, and you work over 40 hours in a work week, you are entitled to time and a half pay for those additional hours. This is called overtime. I think everybody's familiar with it, but if you're not being paid for those additional hours, that is a violation of the FLSA. And you can file a complaint with the Department of Labor. If you're not being paid minimum wage, you can file a complaint with the U.S. Department of Labor. I've got a link here again to where to file those complaints. The process is basically like when you file your complaint, there will be a decent amount of information you need to fill out. So, go look at what's required in a complaint, and you may need to go do some information gathering, things like making sure you've got copies of pay stubs, making sure you've got copies of, your hours, what are your attendance, things like that. to back up whatever your claims are. So if your claim, for example, is that you weren't paid overtime, you're going to need to show what you were paid, what your hourly wage is, and then also, proof of the hours you worked. You can always reach out to the DOL for advice and help on how to file. And then after you file, the DOL is going to reach out to you, figure out if an investigation is the best course of action, what the best course of action is. But that's the basic complaint process with the federal DOL. The North Carolina Wage and Hour Act is really similar. Minimum wage is the same. If you're an hourly employee, you're entitled to overtime for any hours you work over 40 hours in a work week. But additionally, if you're terminated, your employer must pay you all the wages you're owed by the next regular payday. I know that this is something that employees do frequently come across is, you're terminated or you quit your job and you work on commission, for example, and you know that you earned commissions under your employer's commissions policy. You know that you earned $2,000 of commissions that you would have been paid in the next payday. You quit your job and you never see that $2,000. That would be an example of a wage violation, and you should file with the North Carolina Wage and Hour Division if you think you haven't been paid all the wages you should have been paid once you were terminated. You can also file with them for, failure to pay overtime, et cetera, the same way you can with the Department of Labor. I don't have the link on here, which I don't know why, but I can include it when I send the slides. But there is they walk you through the process online of how to file a complaint, what that looks like. And similar to the DOL, they're going to include, what information you need to provide. You may need to go gather more information, like pay stubs, et cetera, to make sure that you've got all the information in that complaint that the Wage and Hour Division is going to need in order to investigate your claim. So when thinking about, should I be filing with the Department of Labor or should I be filing with the North Carolina Wage and Hour Division, to the extent that you think you haven't been paid properly, that you're not being paid at least minimum wage, that you haven't been paid overtime? So minimum wage complaints, if the company and this is a little complicated, but if the company does gross sales or annual dollar volume of less than $500,000, and you may not have this information, but to the extent you do. So if it's a smaller company, they do less than $500,000 of gross annual revenue, you should file with the North Carolina Department of Labor. They're going to be the agency that's going to be best equipped to enforce the law for your employer. If you work for an employer that does over $500,000 in gross annual revenue, or your employer, you work in agriculture, government agencies, hospitals, preschool, schools, nursing homes, things that include basically government funding, you should file with the U.S. Department of Labor and not the North Carolina Department of Labor. Again, you can file based on minimum wage violations, overtime violations, wages involving tips, and wages that include overtime. If you're filing with the North Carolina Department of Labor, the Wage and Hour Division in North Carolina is opposed to the federal Department of Labor. Things like your final paycheck, you didn't get paid out vacation properly, your employer made unauthorized deductions to your paycheck, your pay was reduced unlawfully, you didn't get pay stubs, you don't have records of your payment, which your employer is obligated to provide you, you should file with the North Carolina Department of Labor Wage and Hour Division. Again, you can file a complaint online. The website will walk you through that process. And I believe that there's contact information, and I'll provide the link, but I believe there's contact information there too for you to reach out to the Wage and Hour Division to ask for help filing a complaint, to ask questions. And they include like a frequently asked questions page that you can check to give you a little bit more information as you're filing. All right, I walked through that very quickly. Definitely want to hear if you guys have questions, if there's anything that you're like, can you go back to that? I didn't quite understand. Or if there's any, more specific questions that you have about things that you've experienced, specifically with your employer. And Shelby, do we have any questions in the chat?
It looks like one attendee was looking for a copy of the PowerPoint presentation, which we'll share afterward. We'll provide that to Belinda here at the North County Library for distribution, and we can also post it on our website as well.
Okay, perfect.
I have a question. Can you hear me?
Yes, I can.
Sorry, my voice is hoarse, but I'm Keith, and I'm planning to start my own transportation business, and I'm a veteran. The BB8 sent me to a SCORE mentor, and the SCORE mentor asked me to speak with an attorney through the free library to learn what I need to consider and keep in mind, when doing this. So that's what I want to ask you. Thank you.
So what sort of a transportation company?
A veterans transportation service transporting veterans to and from their appointments.
And is that based here in North Carolina? I mean, in Mecklenburg County?
Yep, right here in Charlotte. I'm retired military, actually.
Got it. Well, Shelby, you pipe up if you've got ideas for resources. But I do wonder if you couldn't reach out to, there's an organization called Climb, here based out of Mecklenburg County, that, and let me, I want to make sure I'm giving you what Climb stands for. I want to make sure I'm getting it correct.
And I just dropped that link in the chat as well.
Beautiful. So the Charlotte Legal Initiative to Mobilize Businesses. So this is an organization that specifically provides legal resources to local companies, specifically to entrepreneurs and small business owners that are either low income, historically underrepresented, or under-resourced. So love that this is, started by a veteran, would be serving veterans. This may be, exactly the kind of business that Climb, would work with. And they do great work over there. That's the first place that I would start. To the extent that they don't have resources for you, or they're like, hey, we can't help you, they will have other resources to provide you. But I think that's the best place to start.
Thank you all so much. I'll definitely start there. Okay,
that sounds great. And good luck.
Thanks.
Any other questions about anything I've covered? Anything that's front of mind for y'all right now that you'd really like to talk about?
And while I'm keeping an eye on the chat, I just wanted to let everybody know there's some additional copies of the links that Rachel had mentioned in her presentation also in the chat if you need to pull those up easily. We also have a couple of these links also available here on our website here at the Mecklenburg Bar. We provide kind of a directory of resources from here in Mecklenburg County and across the state if you do need to access all of that in one place. I will include that as well.
Perfect. Thank you so much, Shelby. And before I send you the PowerPoint, I'll update with some of the links that I noted that were missing on certain slides.
And I'll add as well, if folks have questions that are specific that you need one-on-one guidance with an attorney, we also provide a lawyer referral service. The state of North Carolina, the North Carolina Bar Association also provides a referral service that covers all counties in North Carolina. We're pretty much kind of limited to Mecklenburg County specifically. But of course, if you need to speak to an attorney one-on-one, those referral services are also available.
Thank you, Shelby. Well, y'all are making my job easy if it's just the one question. But I appreciate you joining today and taking the time out. I hope this has been useful. We'll, like we said, we'll make sure that the slides are available. Please do, feel free to look at the chat for those links that Shelby dropped in. But otherwise, thank you for being here today.